The crack in the asphalt ran about 14 feet, starting just past the storm drain, and splitting toward the curb like a fault line that had been ignored for too long. I crouched down and pressed 2 fingers into it, deep, the kind of neglect that takes years to build up and 10 minutes to document. I pulled out my phone, took 3 photos, straightened up, and kept walking. I wasn't trespassing. I want to be clear about that, because the next 20 minutes would make it seem otherwise. I was doing what any landlord does the first time he sets eyes on a property he just acquired. He walks it. He looks at the condition of things. He takes notes. He starts making a list. I had the manila folder tucked under my left arm. I'd been carrying it since I left my car. It wasn't thick, maybe 30 pages, but it was the kind of 30 pages that could end a 6-year reign in a single afternoon if I chose to use it that way. I wasn't ready to make that choice yet. So I just walked, and I looked at the cracked asphalt, and I breathed the cool morning air of Maplecrest Drive. I'd made it maybe 200 feet when I heard her. Hey, excuse me." The voice came from my left, sharp and carrying, the tone of someone who had spent years making sure people heard her before they saw her. I turned. She was already moving toward me from the direction of the Clubhouse 50s, trim, wearing a polo shirt with a small embroidered logo I'd later confirm read Maplecrest HOA board in navy thread. A man trailed behind her, heavy-set, wearing the same logo and the expression of someone who had never once questioned whether the person in front of him was right. That was Diane Colwick. The man was Reed Harmon, her vice president, and from what I'd read in 6 years of meeting minutes, her echo. "This is HOA property," Diane said, planting herself about 4 feet in front of me. Not a greeting. A declaration. "Residents only. You need to leave right now." I looked at her calmly. "I'm not in your HOA." It was a true statement. Technically, precisely, legally true. I was not a member of the Maplecrest Homeowners Association. I never had been. What I was, as of 11 days prior, was something else entirely, but I saw no reason to explain that yet. Diane blinked. I don't think she'd been expecting agreement. She'd been expecting an argument, or an apology, or someone pulling out a resident ID. My calm seemed to confuse her for exactly 1 second before it rearranged itself in her mind into something she could work with. Proof that I was a problem. "I don't care what you think," she said. Louder now. Loud enough that the woman on the porch, 3 houses down, could hear her, which I suspected was intentional. "This is a private road. You are trespassing. I'm calling the police." Reed already had his phone out. He held it up slightly, like a prop in a play he'd performed before. "That's your right," I said. I didn't move. I didn't explain. I shifted the manila folder under my arm and waited. There were 2 residents watching. I noticed them in the way you notice things when you've been trained to keep your eyes moving, not staring, just present. An older woman, 70s, standing just inside her screen door, with a coffee mug she'd forgotten to drink from. A man in his late 30s at the end of a driveway 2 houses up. A kid's bicycle half lifted in his hands, now completely still. Neither of them looked at me with suspicion. They looked at Diane with something I recognized immediately. The particular exhaustion of people who had seen this before and already knew how it ended for the person on my side of it. It took Officer Wes Drummond 9 minutes to arrive. He was professional, unhurried, and he greeted Diane by name, which told me everything I needed to know about how often she made this call. "This man has been walking the private road and common areas," Diane told him, gesturing at me. "He refuses to identify himself and refuses to leave HOA property." Drummond looked at me. I reached into my shirt pocket and handed him a business card. Not the folder, just the card. Name, LLC, phone number. "I have documents I'm happy to share, officer," I said, "but I'll let her finish." Drummond glanced at the card, glanced at me, then turned back to Diane and asked her to walk him through the situation. She was happy to oblige. She told him the road we were standing on was HOA property. She told him the clubhouse lot, the common areas, the green space at the entrance, all of it belonged to the Maplecrest HOA Corporation, had for decades. She said this with the confidence of a woman who had never once considered that the ground under her feet might have a different story to tell. Drummond wrote it down. I stood 10 feet away, folder under my arm, and listened to Diane Colwick describe my property to a police officer. She was thorough. She was convincing. She used the phrase, "We own this road twice." I let her finish. Reed Harmon nodded the whole time, which I found privately entertaining. There's something almost elegant about watching someone build a case against themselves in front of a uniformed witness. You just have to be patient enough to let them do the work. Eventually, Drummond walked over to me. He was polite. He asked if I could stay off the common areas until the matter was sorted. I said I could do that. I thanked him. I walked back to my car. In my rearview mirror, I watched Diane say something to Reed. She was smiling, the kind of smile that comes from having done this before and always gotten the same result. She had no idea, not even close. What Diane Colwick didn't know, what none of them knew, was that the deed to the ground she was standing on had my name on it. Had been for 11 days. Let me tell you how Maplecrest came to be the kind of place where a woman could call the police on a stranger, standing quietly on a public-facing road, and fully expect it to work in her favor. It starts, like most stories about power, with a man who built something and a family that decided they owned it forever. Maplecrest was developed in the late 1980s by a man named Gerald Colwick, Diane's father-in-law. Gerald built 96 homes on a parcel of land in the outer suburbs, sold every one of them, and walked away with a considerable amount of money. But Gerald was the kind of developer who understood that the real long-term value wasn't in the houses. It was in the ground underneath everything else: the private road, the common green spaces, the clubhouse lot, the entrance markers. Everything the residents would use every single day but never technically own. Gerald kept all of that in a separate entity, Colwick Properties, LLC. The homeowners got their houses. Gerald kept the foundation. When Gerald died, that LLC passed to his son, Doug, Diane's husband. Doug was not a businessman. Doug was the kind of man who inherited things and then lost interest in maintaining them. Within a few years, Colwick Properties LLC had gone dormant. No active filings, no renewed ground lease with the HOA, no tax payments on Lot 0A, which was the county's designation for the common area parcel, the road, the clubhouse land, all of it. Just silence, accumulating like interest. I'll come back to that part. What Doug did manage to do before losing interest entirely was hand Diane a seat on the HOA board. That was 6 years ago, and Diane, unlike her husband, was very interested in maintaining things, specifically her grip on them. Within her first year, she restructured the board's voting procedures through a bylaw amendment that passed at a meeting where only 11 of 96 homeowners showed up. The notice had gone out 4 days before, over a holiday weekend. Within her second year, the 2 board members who had publicly disagreed with her on the pool resurfacing budget found themselves cited for violations. One for a satellite dish mounted 2 inches outside the approved zone. One for a basketball hoop that had been in the same driveway for 9 years without complaint. Both resigned from the board within 3 months. Reed Harmon, whose primary qualification appeared to be absolute loyalty, filled one of the vacated seats. By year 3, Diane had built exactly what she wanted. A board that voted the way she told it to, and a community that had learned, through a series of painful lessons, that disagreement had a price. The price was very specific. It came in the form of notices. There was a system, and I want you to understand how precise this system was, because it matters later. Diane's HOA had a fine schedule that started at $75 for a first violation and escalated to $250 for a third. On its face, reasonable. In practice, the violations themselves were the weapon. Grass measured to the centimeter with an actual ruler. I saw the photos later, taken by Reed himself. A wind chime cited as a noise-producing exterior ornament under a provision that, when I finally cross-referenced it against the recorded bylaws on file with the county, did not exist in that language anywhere. A mailbox post painted heritage cream instead of the approved colonial white, 2 colors that, I will tell you honestly, I could not distinguish from each other in the photograph. But the one that stayed with me was Vera's. Vera Hutchins had lived at 14 Maplecrest Drive for 22 years. She'd painted her shutters the same shade of muted beige since the house was new. Then Diane updated the approved color palette, a document she distributed by email to the community, with no vote, no formal amendment process, just a PDF, and suddenly Vera's shutters were non-compliant. The first notice was $75. Vera wrote back asking for clarification and a copy of the formal amendment. The second notice, issued before Vera received a response to her letter, was $250. The third came 2 weeks later with a bolded line at the bottom. Continued non-compliance may result in lien proceedings against your property. Vera was 73 years old. She lived alone. The house was paid off and it was everything she had. She paid the fines, all $3,400 of them, over the course of a year, because she was terrified. She repainted the shutters, a color she couldn't afford to have mixed twice, hoping she'd gotten it right. She had. But she'd still lost $3,400 for a rule that was never properly voted into existence. Cal Renner, 2 doors up from Vera, had a different experience. Cal had lived in Maplecrest for 4 years with his wife and 2 kids, and his mother-in-law, Adele, who had a deteriorating hip and needed to park close to the front door when she visited. The HOA allowed parking exemptions for medical necessity. It said so in the bylaws, right there in Article 7, Section 4. Cal applied for one, submitted Adele's doctor's letter, and received an approval within 30 days. Everything legitimate, everything documented. Then, about 8 months later, Cal voted against a dues increase at an HOA meeting. The increase would have taken monthly fees from $180 to $220. Cal stood up, asked where the additional $40 per household per month was going, and requested an itemized breakdown. Diane told him the board would take his concerns under advisement. 2 weeks later, his parking exemption was revoked. The letter cited changed circumstances and was signed only by Diane. No board vote, no explanation of what circumstances had changed. Just gone. Adele stopped visiting as often after that. She couldn't manage the walk from the street. 96 homes paying $180 a month. That's $17,280 every single month flowing into the HOA's accounts. I pulled the financial disclosures the HOA was required to file with the state. These are public records, available to anyone who knows where to look, and I found a line item that appeared every single month for 4 years running. Administrative processing fee, Crestview Management Services, $4,100. No itemization. No breakdown of services rendered. Just $49,200 a year for 4 years straight, paid to a company I looked up in the state business registry in about 90 seconds. Crestview Management Services was registered to one owner, a woman named Bev Solis, Diane's first cousin. The HOA's own fiduciary guidelines required related party transactions to be disclosed to residents annually. I checked 4 years of meeting minutes. The name Crestview appeared 0 times in any disclosure context. Bev Solis appeared 0 times. $197,000 over 4 years, quietly moving from 96 families into the pocket of Diane's cousin, while Vera Hutchins was being fined for the color of her shutters. Now here's what none of them knew about me, and what I hadn't told anyone yet. I wasn't a neighbor. I wasn't a concerned citizen. I wasn't even someone who had set out looking for Maplecrest specifically. I was a commercial real estate investor with 15 years in the field and a background. Before that, as a title examiner, meaning I had spent the better part of a decade reading deed chains the way other people read novels. I understood how property ownership moved through time. Who held it? Who lost it? What happened when the paperwork stopped getting filed? I had come across Lot 0A, the Maplecrest Common Area parcel, while doing due diligence on a completely unrelated deal in the same county. I pulled the plat, cross-referenced the tax records, and found something that made me set down my coffee and read it twice. The parcel had been transferred out of Colwick Properties LLC 3 years prior, not to the HOA, but to a different holding company, dormant, with 2 years of delinquent property taxes sitting on it like unclaimed luggage. The HOA, as far as county records were concerned, had never owned the ground their clubhouse was sitting on. They'd been operating on a ground lease that expired and was never renewed. I ran a quiet title action. My attorney confirmed the position was clean. I paid the back taxes, completed the acquisition, and received a recorded deed transferring Lot 0A, all 3.4 acres of common area, private road, and clubhouse land to my LLC. I did this quietly. I did not announce it. I did not send a letter to the HOA. I wanted to understand what I'd actually purchased before I introduced myself. So I went to walk the property. That was the morning Diane called the cops on me. I didn't buy that land to be a hero. I bought it because the numbers worked and the deed was available. But the more I read about what had been happening inside those 96 homes, the more I understood that what I held in that manila folder was more than a real estate investment. It was leverage, and I was going to use every inch of it. 3 days after the police incident, a certified letter arrived at my LLC's registered address. I knew it was coming. When someone like Diane Colwick calls the cops, and the cops leave without arresting anyone, there are exactly 2 things she can do next. Accept that she has no actual authority, or escalate. In 6 years of running Maplecrest, the way she ran it, Diane had never once chosen the first option. So I wasn't surprised when I signed for the envelope, set it on my kitchen table, and found the letterhead of one Fletcher Grode, attorney at law, staring back at me. I read it twice, slowly. The way you read something you already know is going to matter later. Grode's letter accused me of trespassing on HOA-managed property, harassment of board members, and I want you to appreciate this one interference with HOA operations. That last charge was never defined. It appeared to mean that my presence while Diane was speaking had somehow disrupted the smooth functioning of a private homeowners association, which, if true, suggested the HOA's operations were considerably more fragile than advertised. The letter demanded I stay off all common areas, the private road, and any property owned or managed by the Maple Crest HOA Corporation. It cited the relevant trespass statute. It concluded with a paragraph informing me that failure to comply could result in civil litigation, seeking damages of up to $50,000. $50,000 for standing on a cracked road holding a folder. I set the letter down, picked up my phone, took a photograph of it. Then I opened my laptop and pulled up the county recorder's database, a website I had used so many times over the years that I could navigate it the way most people navigate their own kitchen. I typed in the parcel number for Lot 0A. The screen loaded. There it was. Deed recorded 11 days prior. Grantee listed as my LLC. Instrument number stamped in the upper right corner. Clean. Unambiguous. Fully public. Then I placed Grode's letter next to my laptop and read his key line again. The private road, common areas, and clubhouse parcel known as Lot 0A, Maple Crest Subdivision, are owned by the Maple Crest HOA Corporation. Lot 0A. He had named the parcel. Specifically, in a legal letter, on his firm's letterhead. He had just put in writing, on behalf of his client, a factual claim about a specific piece of real property. A claim I could now prove was false, with a single page from the county recorder's office. I photographed Grode's letter a second time, this time with my laptop screen visible in the frame, the deed record open beside it. Then I filed both in a folder I labeled, simply, Exhibit A. I did not call Grode back. Instead, the next morning, I drove to Maple Crest. Not to confront anyone. I wasn't there for a fight. I was there because I was a property owner conducting a reasonable inspection of an asset I had recently acquired, and what I found when I looked carefully was not encouraging. The road surface, I'd already documented 14 feet of cracking near the storm drain, more stretching toward the east entrance. The clubhouse exterior hadn't seen fresh paint in at least 4 or 5 years. The trim along the roofline was peeling in long strips, and one of the gutters on the north side had pulled away from the fascia and was hanging at an angle, held in place by what appeared to be a single remaining bracket and optimism. The no trespassing signs posted at both ends of the private road were sun-faded, and one was tilting, its post having worked loose from the ground. My property, in poor condition, maintained, or more accurately, not maintained by an organization that had been collecting $17,000 a month from 96 families for years. I photographed everything, systematically. The cracked asphalt, the peeling trim, the hanging gutter, the faded signs, the clubhouse side entrance where a weather strip had pulled away from the doorframe and nobody had replaced it. I moved methodically, not quickly, because I wasn't trying to hide what I was doing. I was documenting it. I had been at it for about 20 minutes when I heard the front door of a house open behind me. I told you, Diane's voice. I turned. She was crossing her lawn toward the road, and her expression had moved past annoyance into something harder, the look of a person who has decided that this particular situation has gone on long enough, and she is going to end it. Our attorney sent you a letter, she said, stopping about 6 feet away, closer than last time. You were served. You are not welcome on this property. The next time I see you here, I am getting a restraining order. I got the letter, I said. Thank you. She waited for more. I didn't give her more. There is a specific kind of silence that unsettles people who are accustomed to having the last word, and I had learned a long time ago to let it sit. You think this is funny? Her voice rose, and I was aware, as I always was in these moments, that we were outside, on a street, in the middle of a weekday morning, and that sound carries. We will own you in court. You have no idea who you're dealing with. She used the word own. Standing on land that belonged to my LLC. I noted it the way I noted everything quietly, without expression, filing it away. Have a good morning, Diane, I said, and I walked back to my car. She called something after me. I didn't catch all of it. The word lawyer featured prominently. I was 2 houses from my car, when I heard a different voice, quieter, closer to the ground. "Excuse me." Vera Hutchins was standing at the edge of her driveway, holding the screen door open with one hand, speaking at a volume carefully calibrated to not reach Diane. I walked over. She looked up at me with an expression I had seen before in other contexts on people who had been dealing with something for so long they had almost stopped believing anyone else could see it. "She does this to everyone," Vera said. Not a complaint, a statement of fact, delivered with the resignation of someone reporting the weather. "There's a list of us she's destroyed." I looked at her steadily. "I know," I said. "I've been reading the meeting minutes." Vera stared at me for a moment. Something shifted in her face, a slight recalibration, a question forming behind her eyes that she didn't quite ask out loud. "Who are you?" I gave her a small nod. Then I got in my car and drove away. I sat with Grode's letter on my passenger seat the whole drive home. I thought about the specific confidence required to send a cease and desist, citing the ownership of a named parcel, Lot 0A, right there in the text without first checking whether your client actually owned it. Either Grode hadn't verified the title, which was a remarkable oversight for a real estate matter, or Diane hadn't told him the full picture, which was a different kind of problem. Either way, the letter was now in my possession, dated, signed, and making a specific false claim about a specific piece of real property. I stopped at a frame shop on the way home, not because I thought I'd actually hang it, just because the impulse felt right. Their attorney had just sent a cease and desist to the man whose name was on the ground lease. I framed it. I didn't knock on Vera's door. That felt too direct, too visible. I had no way of knowing whether Diane watched the street from her window, and I didn't want to put Vera in the position of being seen talking to the man the HOA had just threatened with a $50,000 lawsuit. So, I wrote a note on a plain index card, nothing identifying on the outside, and left it tucked at the base of her mailbox post on the public side edge of the sidewalk. Just my name and a phone number, and 4 words. "I'd like to listen." She called that evening, around 7:30. Her voice was careful at first, the measured caution of someone who had learned that expressing an opinion in Maplecrest came with consequences. But within about 10 minutes it loosened, and what came out over the next hour was not a complaint so much as a testimony. Organized, detailed, the kind of account that only comes from someone who has been carrying it for a long time and finally found somewhere to set it down. Vera had kept everything. That was the first thing that struck me. Every fine notice Diane's board had ever sent her, $75, $250, the escalating sequence that had eventually totaled $3,400 was in a shoebox in her hall closet, rubber-banded by year in chronological order. Vera had written the date she received each notice in pencil in the upper right corner, and in several cases, she had attached her own handwritten response and the HOA's non-reply. 22 documents in total, spanning 14 months. I asked if I could come by and look at them. She said yes. The next afternoon I sat at Vera's kitchen table with her shoebox and a yellow legal pad, and I went through every document while she made coffee she never drank and watched me from across the table with an expression that was equal parts hope and the long-practiced anticipation of disappointment. I read slowly. I cross-referenced each cited violation against a copy of the Maplecrest HOA bylaws I had pulled from the county clerk's records, the officially recorded version, the one that had been on file since the HOA's formation, and amended through the proper process only 4 times in 30 years. 3 of the violations Vera had been fined for cited bylaw provisions that did not exist in the recorded document, not provisions that had been amended or superseded, provisions that had simply never been there. One cited Article 9, Section 2, Subsection C, regarding exterior color uniformity. Article 9 of the recorded bylaws governed dispute resolution procedures. It had no Section 2, Subsection C. Another cited a rule about decorative exterior elements that appeared nowhere in any version of the document I had. A third referenced an updated color compliance schedule distributed to residents in March, a PDF Diane had emailed to the community with no vote, no amendment process, and no recording with the county. A document she had simply written and declared to be binding. $3,400. Fined under rules that, legally speaking, did not exist. I kept my expression neutral while I wrote this down, because Vera was watching me, and I didn't want to give her hope that wasn't yet actionable. But I will tell you that sitting at that table, going through a shoebox of notices sent to a 73-year-old woman on a fixed income for violating rules someone had invented and never formally adopted, I felt something shift in my chest that was not quite anger and not quite resolve. It was the particular feeling of a man who has been patient for weeks and is now beginning to understand exactly how patient he needs to stop being. Over the following 3 days, Vera introduced me to 6 other residents. We met quietly, a walk around the block here, a conversation in someone's garage there. None of them knew who I was beyond my name and the fact that Vera trusted me. I listened more than I spoke. What I heard was a pattern so consistent it had the quality of a system. Petty citations that escalated when challenged. Selective enforcement that seemed to track closely with whether you had recently agreed with Diane at a board meeting, and a pervasive background hum of anxiety that had settled over the community like weather. Cal Renner told me his story in his driveway, voice low, one eye on the street. He walked me through the timeline precisely. Applied for the parking waiver, submitted the medical documentation, received written approval, voted against the dues increase 5 months later, asked publicly for an itemized breakdown, waiver revoked 2 weeks after that, under Diane's signature alone, citing changed circumstances with no explanation and no board vote. I asked Cal if he still had the original approval letter. He went inside and came back with it in 45 seconds. He'd been keeping it too. A lot of them had been keeping things. I was finding not because they thought it would ever matter, but because keeping things was the only form of resistance available to them. I pulled Article 7, Section 4 of the recorded bylaws that evening. Medical necessity exemptions required a 2/3 board vote to grant or revoke. The revocation letter bore 1 signature. The math was straightforward. A 3-person board needed at least 2 votes. Diane had supplied 1. Cal's parking exemption had been revoked through a process that violated the HOA's own governing documents. That night, I opened the HOA's state financial filings on my laptop annual disclosure reports, publicly accessible, the kind of document that most people never look at because they don't know it exists. I cross-referenced the expense line items against the state business registry. The entry appeared every month without exception for 48 consecutive months. Administrative processing fee Crestview Management Services, $4,100. I found Crestview Management Services in the registry in under 2 minutes. Sole registered agent and owner, Beverly Solis. I ran Beverly Solis against Diane Colwick in a basic public records search and found what I had already half expected. A shared address going back 15 years, family photographs on a public social media profile, and a 2019 county property record listing them as co-inheritors of a small estate. First cousins, $197,000 over 4 years. Paid to a company owned by a family member. Never disclosed in any meeting minutes, any annual report to residents, or any filing with the state HOA Oversight Board, as required by Article 12. Section 1 of the governing documents Diane had been enforcing against everyone else. It had never happened. Not once. But the thing that stopped me coldest, the thing I sat with for a long time before I moved on, wasn't the fines or the related party payments. It was a document I found when I was reviewing the HOA's original formation papers, which I had requested from the county clerk as part of my title research. Buried in the formation packet, dated the same year Maple Crest was developed, was the HOA's original title insurance policy. Title insurance exists to protect against ownership disputes. It's a standard part of any property transaction, and what it covers tells you something precise about the nature of the ownership being insured. The policy covered the HOA's interest in the common areas. And, in the coverage description, in plain language, it listed Lot 0A as subject to ground lease from Colwick Properties LLC, not fee simple ownership, a lease. The HOA had never owned the land. They had leased it from Gerald Colwick's company, and when that company went dormant and the lease expired unrenewed 2 years ago, their legal right to occupy and operate that property had quietly lapsed. They had continued operating, collecting dues, posting signs, calling police on visitors as though nothing had changed. Because nobody had told them. Because nobody had been watching. Until now. Diane had been ruling a kingdom built on a foundation she didn't actually own, and for the last 2 years, she hadn't owned it at all. I closed my laptop, picked up the phone, called my attorney, Sloan Whitfield, and told her I was ready to start building the formal receipts packet. I want to tell you about the moment Diane Colwick made her biggest mistake. Not the moment she called the cops, though, that was a mistake. Not the moment her attorney named Lot 0A in a legal letter without verifying the title, though, that was a worse one. The biggest mistake came about 3 weeks after Grode's cease and desist, on a Tuesday morning, when the Maple Crest HOA filed a formal lien against my LLC with the county recorder's office. $8,750. That was the number on the lien document. Itemized as follows. Trespassing damages, $2,000. HOA administrative processing fees for unauthorized common area access, $4,500. Legal costs incurred in issuing the cease and desist, $2,250. The lien was signed by Diane Colwick as HOA president and filed under my LLC's name against the Maplecrest common area parcel address, which was, of course, Lot 0A, my property. They had filed a financial claim against the fee simple owner of the land they were sitting on. I found out because my LLC received a county notice of recorded encumbrance. Standard procedure when a lien is filed against a property associated with your entity, the county mails a notice to the registered address. I read it standing at my kitchen counter, still holding my coffee. Then I set the coffee down very carefully, because I did not want to drop it. I called Sloan Whitfield. She picked up on the second ring. I read her the lien figures and the basis for the claim. There was a pause on her end, the particular pause of an attorney who is simultaneously processing a legal filing and deciding how to characterize it to a client without using the words she actually wants to use. This is one of the more legally reckless things I've seen in 15 years of HOA work, she said finally. A lien requires a valid legal basis, a legitimate debt, a proper process, standing to file. The HOA had none of these things against my LLC. You cannot levy administrative fees against the owner of property you do not own. You cannot claim trespassing damages against the landlord of the ground you're operating on. The entire filing was, in Sloan's precise language, procedurally defective, factually unsupported, and strategically catastrophic for the party who filed it. She said that last part with a composure I recognized as the professional equivalent of barely suppressed delight. We drafted a formal demand letter that afternoon. Certified mail, return receipt requested, addressed to both the Maplecrest HOA board and to Fletcher Grode personally. The letter demanded removal of the lien within 14 days, cited 4 specific statutes governing improper lien filing and HOA authority limitations, and attached a single document as Exhibit A, the recorded deed showing my LLC as fee simple owner of Lot 0A, pulled directly from the county recorder's database. This was the first time anyone in the HOA's orbit had seen the deed. I want you to think about what that meant for Fletcher Grode. He received a certified letter from my attorney, opened it, read the demand, turned to the attachment, and found himself looking at a county-recorded deed that directly contradicted the central factual claim he had made in his own cease and desist letter 3 weeks earlier. He had stated in writing, on his firm's letterhead, that Lot 0A was owned by the Maplecrest HOA Corporation. The document now in his hands said otherwise. Had said otherwise for over a month. Had been publicly available in the county database the entire time. Sloan told me later that Grode called her within 2 hours of receiving the letter. He was, in her words, notably subdued. He said he would advise his client to consider the demand seriously. He used the phrase possible clerical misunderstanding regarding the ownership history, which was an interesting characterization of a 30-year chain of title. Sloan told him the 14-day window was firm. Then Grode called Diane. I wasn't in that conversation, but I learned the substance of it later, during discovery, when Grode's notes became part of the record. His recommendation was to remove the lien, acknowledge the ownership issue, and negotiate a ground lease arrangement. He described the HOA's legal position as significantly compromised. Diane's response, per his notes, was, "That can't be right. We've always owned that land." Grode apparently pushed harder. Diane told him to find another angle. He said there wasn't one. She told him to look harder. The 14-day deadline came. The lien was not removed. What arrived instead, on day 16, was a counter letter from Grode, citing the HOA's historic use and possessory rights over the common area, an argument that essentially claimed that because the HOA had been operating on the land for decades, they had developed a legal right to continue doing so, regardless of what the deed said. It was, Sloan told me when she called, a genuine legal argument, just not a very good one in this particular fact pattern. He's throwing what he has, she said. He doesn't have much. But it meant we were going to court. The hearing date was set. What happened next was something I had not anticipated, and it changed the shape of everything. Diane called an emergency board meeting. The notice went out to all 96 homeowners by email on a Wednesday afternoon, and the subject line read, "Urgent. Threat to our community, all residents encouraged to attend." I received a copy because my LLC was registered in the county, and someone I suspected, Cal, quietly had made sure I was on the distribution list. The email described me as an outside real estate speculator attempting to exploit a paperwork technicality to seize control of community property. It did not mention the deed. It did not mention the expired ground lease. It did not mention that the HOA had filed a lien that my attorney had characterized as legally reckless. It told residents that their homes and their community were under threat from a predatory investor and that they needed to show up and demonstrate unity. I read it twice. I thought about Vera, who would receive this email and understand exactly what was happening. I thought about Cal, who would receive it and feel the familiar chill of a target being painted on someone Diane had decided was a problem. I thought about the other people I had met over those 3 days of quiet conversations in garages and on sidewalks. People who had been living inside this system for years and had stopped believing it would ever be different. I thought about what it cost Diane nothing to send that email. How easy it was to describe the truth as a threat when you controlled the language and the distribution list and the room. I did not attend the emergency meeting. I was preparing for something more permanent than a meeting. But I had one more thing to document before Thursday. I spent 2 afternoons walking my property again, the road, the clubhouse exterior, the common areas, and this time I brought a contractor I had worked with for years on other projects, a man named Doyle Ramstad, who had no connection to Maple Crest and no stake in what I was doing. Doyle walked every inch of Lot 0A with me and put his observations in writing: deferred maintenance on the road surface, estimated repair cost $4,200. Roof edge and gutter system on the clubhouse requiring immediate attention, estimated repair cost $3,800. 2 exterior door frames with compromised weather sealing. Total documented deferred maintenance. Just under $9,000 on property the HOA had been representing as their own, funded by $17,000 a month in resident dues. I added Doyle's report to the packet. Sloan confirmed it strengthened the unauthorized use argument. The HOA had not only occupied my property without a valid lease for 2 years, they had allowed it to deteriorate. The hearing date was a Thursday. I told Sloan I wanted to use all of it. Diane had filed a lien against property she didn't own. On behalf of an HOA operating on land they hadn't had a legal right to occupy for 2 years. The hearing date was set for a Thursday. I told Sloan, let's use all of it. The Maple Crest HOA held its regular monthly meetings in the clubhouse on the 2nd Tuesday of every month. The clubhouse sat on the western edge of Lot 0A, about 60 feet back from the private road, a single-story building with a covered entrance and a parking area that could hold maybe 30 cars if people were cooperative about it. I had photographed its peeling trim and hanging gutter 3 weeks earlier. I had the contractor's report in my packet, estimating $3,800 in deferred roof maintenance on the north face alone. It was, in other words, my building, and I was going to hold a meeting in it. Sloan sent the request formally, a written notice to the HOA board, citing my right as a property owner of record in the subdivision area to address the board at a regular public meeting. HOA bylaws in this state required open meetings with a public comment period. Diane could not bar me without violating her own governing documents. Sloan's letter made this clear in 2 paragraphs, with the relevant bylaw sections cited in footnotes. Diane tried anyway. The board sent back a letter through Grode's office arguing that, because my LLC was not a member of the Maple Crest HOA, I had no standing to address a members-only meeting. Sloan responded within 24 hours. The open meeting provision did not require HOA membership. It required only that the matter concern HOA operations, and since the HOA had filed a lien against my LLC and I had a pending court date with their board, my interest in their operations was, she wrote, self-evidently established. She attached the relevant statute. Grode did not write back. Diane backed down. I arrived at the clubhouse 20 minutes early. I want to tell you what it felt like to walk through that door, because it was not what I expected. I had been to a lot of difficult rooms in my life, title, dispute hearings, county board meetings where nobody was happy to see anyone else, negotiations where every person at the table was holding something back. But there was something particular about walking into a room full of people who had been told, by email, that I was a threat to their homes and their community. I felt their eyes before I was fully through the door. Not hostile exactly, more like the careful assessment of people who had learned to read a room the hard way and were trying to figure out which version of this situation they were actually in. I found a seat near the back wall. Set the manila folder on the table in front of me. Did not open it. By 7 o'clock, the room held somewhere between 35 and 40 residents. I recognized Vera near the middle, sitting straight-backed with her hands folded, the posture of a woman who had decided something. Cal was 2 rows behind her, phone already in his hand, tilted at an angle that told me he intended to record. Near the back wall, standing with his arms loosely crossed and no particular expression on his face, was Officer Wes Drummond. Off duty, out of uniform, wearing a gray Henley. I had called him the previous week not to ask for anything official, just to let him know there was a meeting he might find professionally interesting, given that he had filed an incident report involving the same property and the same parties. He said he'd think about it. Apparently he had. Diane opened the meeting at 7:05. She had prepared. I could see it in the way she moved through the preliminary agenda items, dues, reminders, a landscaping update, a brief note about the upcoming pool inspection, with the efficient dispatch of someone clearing the deck before the main event. Reed Harmon sat beside her at the folding table at the front, a stack of papers in front of him he never looked at. 2 other board members, both installed in the last 2 years, sat at the ends of the table and said nothing. Then Diane turned to the matter she had actually called 40 people into a room to address. She spoke for 5 minutes. I timed it. She described me as a real estate investor who had identified what she called a dormant administrative gap in the HOA's property records and was attempting to exploit it for financial gain. She used the phrase, "our community," 11 times. She said the HOA had always maintained and managed the common areas, and that any suggestion of competing ownership was a legal technicality being weaponized by someone with no stake in the lives of the families who live here. She said the HOA's attorneys were vigorously defending the community's interests. She said that what the community needed to do, tonight and in the coming weeks, was stand together. She did not mention the deed. She did not mention the expired ground lease. She did not mention the lien her board had filed, or the demand letter my attorney had sent in response. She did not mention that vigorously defending meant her attorney had received a copy of the recorded deed and called Sloan Whitfield within 2 hours to discuss the possibility of settling. Reed Harmon nodded throughout, which I had come to understand was simply what Reed Harmon did. When she finished, a woman in the 3rd row raised her hand and asked what specifically the administrative gap was. Diane said it was a complex title matter her attorneys were handling. Another resident, a man I didn't recognize, mid-40s, the kind of voice that suggested he was used to asking questions in professional settings, asked whether the HOA had title insurance that covered this type of dispute. Diane said that was also being reviewed by counsel. A 3rd question, from the back. Had the HOA's attorney confirmed they would prevail? Diane said she was confident in their position. She was handling it. I'll give her that. Under pressure, in a room where people were nervous, and some of them were starting to ask the right questions, she held her composure and redirected every probe with the practiced smoothness of someone who had been doing this for 6 years. Nobody in that room except Vera and Cal and possibly Drummond knew what was actually in the manila folder on the table in the back. When Diane opened the floor for public comment, she called my name with the tone of someone calling a name at the DMV. I stood, walked to the front, turned to face the room, not the board, the room. 40 people looking back at me, some wary, some curious. A few with the closed expressions of people who had already decided. "Thank you for having me," I said. "I'll keep this brief." I did not raise my voice. I had no reason to raise my voice. I looked at Diane directly and asked her 3 questions. Is it the board's position that Lot 0A, the common area parcel, including this road and this building, is owned by the Maple Crest HOA Corporation? Diane held my gaze. It is. Is it the board's position that this clubhouse and the private road outside sit on HOA-owned property? Yes. Is it the board's position that no valid competing ownership claim to Lot 0A currently exists? A half-second pause. The kind you feel but can't prove. Yes, she said. That is the board's position. I nodded. 40 people in the room. Cal's phone at a quiet angle. Officer Drummond near the back wall. Vera with her hands folded. Diane's 3 answers, stated clearly, on whatever recording Cal was making, and in the memory of everyone present. "Thank you," I said. "I'll see you Thursday." I walked back to my seat, sat down, did not open the folder. I was aware of the shift in the room, not dramatic, not the gasp and murmur of a movie scene, but the specific quality of silence that descends when 40 people simultaneously realize they may not have the full picture of the situation they are sitting inside. Diane moved quickly to close the public comment period and returned to procedural items. Her voice was even, professional, but I had been watching people in difficult rooms for a long time, and I could see the tension in the way she held the pen she was using to make notes too tightly, the knuckles showing. Reed Harmon leaned over and said something close to her ear. She waved him off without looking at him. Vera caught my eye as I stood to leave. She gave me a small, careful nod, the kind that means I understand what just happened. Cal was still recording. Drummond was already moving toward the exit, unhurried, the incident report from 3 weeks ago, presumably still somewhere in his memory, alongside the 3 answers Diane had just given on the record, in front of a room full of witnesses. I picked up the manila folder from the table, the same folder I had been carrying the day they called the cops. I tucked it under my arm, thanked the room for its time, and walked out into the parking lot of my own building. Before I sat down, I had placed the folder on the table in front of me, the same folder I'd been carrying the day they called the cops. Reed Harmon had stared at it. I think he already knew. Civil court has a particular smell, not unpleasant, just specific. Old paper and climate-controlled air, and the faint residue of 1,000 previous arguments that all believed themselves to be the most important thing that had ever happened in that room. I had been in enough of them to find it almost comfortable. Judge Renata Wold's courtroom was on the 4th floor of the county courthouse, a standard-issue hearing room with fluorescent overhead lighting and a gallery that seated maybe 25. Sloan and I arrived 40 minutes early. I set the exhibit packet on the table in front of me, a 2-inch binder, tabbed and indexed, every document in the order we intended to use it. Sloan had a second copy. There was a third copy for the judge. Fletcher Grote arrived 12 minutes before the hearing. He was a trim man in his late 50s, silver-haired, the kind of attorney whose presentation suggested he was accustomed to being the most prepared person in the room. He sat down across from us, arranged his papers with practiced efficiency, and did not look at me. Diane Colwick sat beside him, in a charcoal blazer, upright, composed. Reed Harmon had come and taken a seat in the gallery behind her. In the row behind Reed sat 4 other Maple Crest residents I recognized, not Vera, not Cal, but 4 people who had, as far as I knew, attended primarily because Diane had asked them to. Vera and Cal came in together 3 minutes before 9. They sat on my side of the gallery. Vera was wearing the same cardigan she'd had on the morning I sat at her kitchen table going through her shoebox. Cal had his phone in his breast pocket. Judge Wold entered at 9 o'clock exactly. She was mid-50s, unhurried. The kind of judge who had heard enough nonsense in enough courtrooms to have developed a very precise internal meter for what was worth her time. She reviewed the case summary, confirmed the parties, and asked Sloan to proceed. Sloan stood. She did not use elaborate language. She had told me the night before that the best thing about this case was that the documents did all the work. Her job was to present them in the right order and then get out of the way. She began with the deed. She handed a certified copy to Judge Wold, walked one across to Grote, and set one on our table. The deed was 4 pages. It showed the full transaction. Lot 0A, Maple Crest subdivision, transferred to my LLC, recorded with the county 38 days prior, instrument number in the upper right corner, notarized signature of the county recorder at the bottom of page 4. Judge Wold read it with the focused attention of someone who was already building a framework in her mind. Grote looked at his copy. His expression did not change, but something around his eyes did the microscopic adjustment of a man confirming that the thing he had been hoping might not be as bad as advertised was, in fact, exactly as bad as advertised. Diane looked at her copy. Then she looked at Grote. He put a hand briefly on the table near her arm, not touching, just present, and she looked back at her copy. Sloan then walked the full chain of title. She had prepared a 1-page diagram, simple, clean, the kind of thing you could follow without a law degree, showing the ownership history of Lot 0A from the original Colwick Properties LLC through the transfer to the dormant holding company, the accumulation of 2 years of tax delinquency, the quiet title action, and the recorded deed. Every step had a corresponding exhibit tab. Judge Wold turned to each tab as Sloan cited it, reading as Sloan spoke. The room was quiet enough that I could hear the pages turning. Then Sloan placed the HOA's own title insurance policy on the table. She explained what it was in 1 sentence. A document issued at the HOA's formation that described the nature of their interest in the common area property. She read the relevant line aloud, slowly. The common area parcel known as Lot 0A was held subject to ground lease from Colwick Properties LLC, not owned. Leased. The HOA had never held fee simple title to the land. Their own insurance policy said so. This document had existed since the HOA was formed and had been sitting in the county clerk's formation packet for 30 years. Grode said, "Objection. The relevance of the formation, era, insurance policy," Judge Wold said. "Overruled. Continue." Sloan continued. She placed Officer Drummond's incident report on the table, the report filed the morning Diane called the police on me, the morning I stood on Maplecrest Drive holding a manila folder and said nothing, while Diane told a uniformed officer that the road was HOA-owned property. The report quoted Diane directly. "This road and all common areas are owned by the Maplecrest HOA Corporation." Drummond, who was sitting in the back row of the gallery in his gray Henley, did not move or speak. He didn't need to. His report was already in the record. Then Sloan opened her laptop and played 34 seconds of audio. Cal's recording from the Tuesday night meeting. 40 residents in the room. My 3 questions. Diane's 3 answers. Her own voice, clear and unambiguous, stating on the record in front of a room full of witnesses that Lot 0A was owned by the HOA, that no valid competing claim existed, that this building and this road were HOA property. 34 seconds. Then silence. Diane's jaw tightened. It was the first visible crack. Sloan set the recording aside and moved to the resident documentation. She presented Vera's fine notices, 22 documents, rubber-banded and photographed, with the relevant bylaw cross-references tabbed beside them. She placed the recorded HOA bylaws next to 3 of the cited violations and showed, side by side, that the provisions Diane had cited did not exist in the official document. She read Article 9 aloud, the dispute resolution section, and noted the absence of any Section 2, subsection C, anywhere in the text. 1-sentence explanation. The HOA had been fining a 73-year-old resident for violating rules that were never formally adopted. 1-sentence consequence. $3,400 collected without legal basis. She placed Cal's parking waiver approval beside the revocation letter. She read Article 7, Section 4 aloud. Medical necessity exemptions require a 2/3 board vote to revoke. She noted that the revocation letter bore 1 signature. She noted that a 3-person board required 2 votes for a 2/3 majority. She did not editorialize. She simply put the 2 documents side by side and let the math speak. Then came the financial records. Sloan laid out 4 years of HOA state filings beside the Crestview Management Services registry entry, beside Beverly Solis's name. She showed the monthly line item $4,100, 48 consecutive months, and the total, $197,000, paid to a company owned by Diane's first cousin, with 0 disclosure to residents in any annual report, any meeting minutes, or any filing with the State HOA Oversight Board, as required by Article 12. Section 1 of the governing documents Diane had been enforcing against everyone else. The room was very still. Diane leaned toward Grode. He was writing something on his legal pad. She said something close to his ear. He wrote something and underlined it twice. Then he set the pen down and did not pick it up again. Judge Wold looked up from the exhibit binder. She had been reading steadily throughout Sloan's presentation, turning pages with the same focused attention she'd brought to the deed at the beginning. She looked at Grode. "Counsel, does the respondent wish to address the ownership documentation?" Grode stood. He was measured. He cited the historic use argument, decades of continuous HOA operation, established community reliance, equitable interest in the property. It was, as Sloan had said, a genuine argument. Judge Wold let him finish. Then she asked one question. Is the respondent aware of any recorded instrument conveying fee simple title to Lot 0A to the Maplecrest HOA Corporation at any point in the property's history? Grode paused for 1 full second. No, Your Honor. Judge Wold nodded. She reviewed her notes for a moment. Then she ruled from the bench. The lien against my LLC was void and ordered removed from the county record within 10 business days. Lot 0A's fee simple ownership was confirmed in my LLC by declaratory judgment. The HOA was ordered to cease representing Lot 0A as HOA-owned property in any public, legal, or recorded document. The financial disclosure irregularities were referred to the State HOA Oversight Board for formal investigation. She said all of this in the same unhurried tone she had used since 9 o'clock. I did not react. I had known more or less how this was going to go for several weeks. The work had been done in Vera's kitchen and at my laptop at midnight and in Sloan's office with a 2-inch binder and a set of exhibit tabs. The courtroom was just where the work was delivered. I reached into the exhibit binder and removed the original manila folder. The one I had been carrying the day Diane called the cops. The one I had set on the table at the HOA meeting while Reed Harmon stared at it. I opened it. Inside was the deed, the title chain, every document Sloan had just presented. The folder I had been carrying since day one. I placed it flat on the table in front of me and smoothed it once with the palm of my hand. Diane had called the police on the man holding proof she didn't own the ground she was standing on. I just waited until she had said it enough times, in front of enough people, on enough records, to make sure it stuck. The lien was removed from the county record 8 days after Judge Wold's ruling. I know because I checked the recorder's database the morning it happened, the same database I had been using since before any of this started, the same screen I had pulled up the night I first found Lot 0A, sitting in a dormant holding company with 2 years of unpaid taxes on it like a door someone had forgotten to lock. I typed in the parcel number. The encumbrance line was gone. I closed the laptop and made coffee. That was the first thing. The second thing happened the following week, when Sloan filed the declaratory judgment with the county recorder as a recorded instrument, meaning that anyone who pulled the title history on Lot 0A from that point forward would find, in permanent public record, a court order confirming my LLC as fee simple owner and prohibiting the Maple Crest HOA from representing the property as theirs in any legal, public, or recorded document. It would be there in 20 years, in 50, the kind of thing that doesn't get forgotten because it doesn't get to be forgotten. Fletcher Grode withdrew from representing the HOA within 10 days of the hearing. He sent a brief professional notice to the board citing irreconcilable differences regarding litigation strategy, which was one way to describe the experience of having your central factual claim dismantled document by document in front of a judge who overruled your only objection. I did not hear from him again. The State HOA Oversight Board opened a formal inquiry into the Crestview Management Services payments within 3 weeks of Judge Wold's referral. I received a courtesy notice because my LLC's legal action had initiated the referral. The inquiry covered 4 years of undisclosed related party transactions totaling $197,000. Beverly Solis, I later learned, retained her own attorney. Diane Colwick was named as a subject of the investigation in her capacity as the board officer who had authorized every payment. Diane resigned from the HOA board on a Thursday afternoon, 12 days after the hearing, 14 days before the first scheduled interview with the Oversight Board investigator. Reed Harmon resigned the following Monday. The 2 remaining board members, both of whom had said almost nothing at any meeting I had ever observed them at, issued a joint statement saying they supported a full community review of board governance and would serve in a transitional capacity until new elections could be held. The elections were held on a Saturday morning in the Maple Crest Clubhouse. 61 of the 96 homeowners showed up, which I was told was the highest turnout in the HOA's history. 3 candidates ran for the 3 open seats. Cal Renner was elected to the board by a margin that wasn't close. A retired school teacher named Margot Finch took the second seat, and Vera Hutchins, 73 years old, 22 years in Maple Crest, $3,400 poorer than she should have been, with a shoebox full of fine notices still in her hall closet, was elected treasurer. I heard about the results from Cal, who texted me a single line that evening. She cried a little. So did I. The first order of business for the new board was the settlement agreement. Sloan had been negotiating its terms with the transitional board members for 2 weeks. The agreement covered 3 things. First, all fines levied against residents under bylaw provisions that did not exist in the recorded governing documents were to be identified, calculated, and refunded within 60 days. The total came to just under $22,000 across 11 homeowners. Vera's, $3,400, the largest single amount. Second, the Crestview Management Services contract was terminated immediately, with the question of repayment to the community to be determined by the Oversight Board's findings. Third, my LLC and the reconstituted HOA board entered into a formal ground lease for Lot 0A, a real lease, properly drafted, with a fair market rate, full transparency, and a 10-year term renewable by mutual agreement. The community now had legal certainty about the ground their common areas sat on for the first time in 30 years. They knew exactly who owned it, what they were paying for the right to use it, and what would happen if either party failed to hold up their end. Vera called me the evening the settlement was signed. She asked if I had known, that first day, how it was going to go. I told her honestly, I had known the legal position was strong, but I hadn't known the people. I hadn't known about the shoebox. I hadn't known about Cal keeping the approval letter in a drawer for 2 years just in case. I hadn't known there would be 61 people in a clubhouse on a Saturday morning who had decided they were done. She was quiet for a moment. Then she said, "We were just waiting for someone who knew what to do with what we already had." I didn't have a response to that felt adequate, so I told her she'd make a hell of a treasurer. She laughed, which was the right way to end that conversation. The first meeting of the new board ran 45 minutes. I know because Cal told me. No one was fined. No one was threatened. 3 items on the agenda, all resolved. Everyone home by 8:30. He said it felt, and I'm using his word, normal. Like a thing that should have always been normal, and somehow hadn't been for 6 years. Doyle Ramstad's crew repaired the road surface, the week after the ground lease was signed. 14 feet of cracking near the storm drain, more toward the east entrance, the same damage I had photographed on the morning Diane called the police. The repair took 1 day. The invoice went through the proper process. Submitted to the new board, reviewed, approved, paid from HOA maintenance reserves that had, it turned out, been significantly underspent on actual maintenance for years. Doyle patched the gutter on the clubhouse north face the same week. The no trespassing signs at both ends of the private road came down. In their place went simple green markers. Maple Crest Drive Private Road. No declaration of ownership. Just a name and a fact. I drove out to Maple Crest on a Tuesday morning, about 3 weeks after the settlement closed. No particular reason, no documentation to gather, no meeting to attend, nothing I needed. I just wanted to walk it once more the way I had walked it the first time. The asphalt was smooth where it had been cracked. The clubhouse trim had been painted. The new board had approved a full exterior refresh as part of the deferred maintenance backlog, and the peeling strips along the roofline were gone, replaced with clean white paint that still had the slightly too bright quality of fresh work. The gutter was flush against the fascia the way it was supposed to be. The entrance markers were neat and unambiguous. I walked the full length of Maple Crest Drive and back, about 8 minutes at a comfortable pace. Vera was on her porch when I passed her house. She had a coffee mug and the same screen door she'd been holding open the day she first spoke to me, in a voice calibrated to not carry as far as Diane's driveway. The shutters on her house were freshly painted, the original muted beige she had kept for 22 years before someone invented a rule against it. They looked, if I'm being honest, exactly the same as they must have always looked. Exactly right. She raised her mug. I raised a hand. 2 houses up. Cal's mother-in-law, Adele, was parked in the front spot, close to the door, the way she always should have been able to park. Officer Drummond pulled up alongside me in his personal vehicle as I was walking back toward the entrance. He rolled the window down. He had the relaxed expression of a man who was not there for any official reason. "Interesting 38 days, he said. 39, I said. From the deed to the ruling. He nodded once, the way people nod when they're acknowledging something they've filed away and don't intend to forget. Then he drove on. I stopped at my car and sat for a moment before starting the engine. The manila folder was on the passenger seat where I'd set it when I got in empty now. All the documents filed with the court and recorded with the county and organized in a binder in Sloane's office. 30 pages that had been under my arm the morning Diane Colwick told a police officer she owned the ground I was standing on. I didn't buy that land to be a hero. I've said that, and I meant it. I bought it because the numbers worked and the deed was available, and something in the title history made me curious. What I found underneath the paperwork was 40 years of people who had stopped believing that anyone would ever push back, who had paid fines they didn't owe and lost rights they were entitled to, and learned to keep the voices down in their own driveways because the cost of speaking up had always been higher than the cost of silence. Sometimes the most powerful thing you can do is simply know what's true. Know it before anyone else does. Know it more precisely than anyone else does. And then wait patiently, quietly. Fold her under your arm until the other side has said the wrong thing enough times, in front of enough people, on enough records, to make absolutely certain it sticks. I put the car in drive. On the way out, I passed the Maple Crest entrance sign, the original one, the dark green rectangle with gold lettering that had said, Maple Crest, a managed community for as long as anyone could remember. Someone had taped a handwritten note on plain white paper to the post below it, small enough that you'd miss it at speed. Under new management, I didn't stop. I didn't need to. I smiled once, turned onto the county road, and drove home.